There was one thing that Melody Farris was very good at, and that is betraying everyone close to her. I went through testimony of her children in this case, even Amanda. She tore our family apart. Mom became hostile, aggressive, demanding money. Even Amanda said, there was manipulation. I should have been more angry at her. And Chris Farris, when he was asked, how do you feel about your mom committing this crime when your daughter was possibly at home? I think it's sick and twisted. He didn't say, oh, I don't think she would do that. These are her children. But as you sit here, she is trying to blame them for this crime. Those are her kids. Let that sink in. She has thrown both her sons, a son-in-law, under the bus for this crime. The murder of her husband, who she betrayed the most. She didn't only take away their father, but she took away a grandfather. She took away a big part of Bern Foreman. But the only thing he was to her was in the way. When she's faced with the reality and the consequences of what she did, the first thing she does, serves up her kids on a silver platter, parades it all around the courtroom. But the evidence in this case doesn't point to a single one of them. This is Gary. He is not a pile of bags of fertilizer. He's a man. It's offensive to compare man to bags of dirt. Now the defense wants you to believe she's just the unluckiest woman ever. There was blood found in her home. There was a bullet found in her home. She was framed. It was planted. That's not reasonable. She just happened to also be having a long-standing affair with a man who's searching for wedding rings less than a week before Gary Farris is murdered. They want you to think that's a coincidence? Man, they're in for it, because there's a long list of coincidences if that's the game they're playing, if that's what they're trying to get at. Not only that, but she just so happened to be taking care of a woman who owned a .38 snub-nose revolver in a leather holster that her son saw in the basement of her home. Another coincidence? No, ladies and gentlemen, that's called evidence. They want you to think there's an individual, innocent, reasonable explanation for all of the incriminating evidence against her. That it's a giant conspiracy. That the gunshot wounds didn't kill him? Use your common sense and reason. Now let's briefly talk about Scott, then we're going to get into the evidence that incriminates Melody Farris. When you think about Scott Farris, think about the manner in which he testified. Think about how he was corroborated, not only by the witnesses in this case, but the digital evidence. The digital evidence proves he was truthful about everything he did that week. Tuesday, Wednesday, Thursday. And he's corroborated by Martha Barton, because you know what? He didn't know that Martha Barton had a gun, a .38 snub-nose revolver in a leather holster. And a huge piece of evidence. He knew Melody the best. He knew his parents. He knew their dynamic. He knew that Melody never had a credit card. He knew that Melody was angry. He was there when she slammed that plate down and said, "God, I can't wait till the day he's dead." He saw that. The day before his father was murdered. He knew that Melody despised Gary. And he would get caught in the middle. He just wanted to bury his head in the sand and be like, let me do my work. Keep me out of the marriage problems. But the second he knew his father was in that burn pile, they want to get on him for taking charge. You know what you learn in the military? To take charge. To take action. That's all he knew. That was ingrained in his mind. We need to call 911. We need to get the girls out of here so they're not traumatized for the rest of their lives. And we need to get to the bottom of this and get to the truth. Talk about lack of motive for Scott. He was completely relied. He completely relied on his father for everything. His livelihood, the place he lived, the money. Why would he take that away? He would have nothing left. Melody would kick him out immediately. He also knew, forgot to mention, Melody disappeared every week to go see Rusty. He knew that. One of her motives. And he didn't have access to a .38 revolver or own one. Think about this. Scott committed this crime. There's no way she wouldn't know about it. She was home the whole time. Law enforcement didn't blue star the barn because nobody saw blood in the barn. They blue starred where there was physical blood. No blood found in the barn. They didn't have to. The bullet was in the house. Gary was on the burn pile.
This is what happens when you leave a plate. Forget to take it upstairs. A minor temper tantrum. Of course, I had supper tonight and it was 6 for me, so I'm sure I'll be feeling poorly here within minutes. But we'll see.
There was testimony about Gary talking about Melody poisoning him. We didn't admit that or get that in evidence because we think he was poisoned. That shows his state of mind. That shows he knew Melody would kill him if it came down to it. She's the only one that would have. And he knew she wanted him dead. She's clearly poisoning me. Supper was fixed for me. I'm probably going to feel bad. And that was after her slamming that plate down on the ground in frustration because he left a dirty plate in the theater or his bedroom or wherever. It's not normal behavior. That corroborated Scott. So, this might be because I'm a millennial, but I always read that first line as, do you have my credit card? Because my phone always fixes due to so, and it just irritates me. But read it however you wish. Gary to Scott, do you have my credit card? So you have my credit card. Choose one. Yes. Hang on to it as if your life depended on it. Is that what you tell someone who you want to cut off? No. That's what you tell someone you trust to keep the credit card away from her. He relied on Scott. Probably a little too much for this dynamic for him, between him and Melody. Probably shouldn't have gotten Scott involved, but here he is. He lives on the property. It's natural. He says, okay, and then he says, she makes me go shopping with her because she keeps saying the other card is turned off, her debit card. The girlfriend of her boyfriend, Rusty Barton, sent me several disturbing emails last night. This is in October of 2017. She is spending dime of my money. Either she is spending every dime of my money or she won't spend I don't know. Something about spending his money. Things will change dramatically. You need to pursue a job soon. He's not telling Scott to pursue a job because he wants him off the property. He's telling Scott to pursue a job because something's about to go down. He's about to leave her. He's had it. But this was almost a year before his death. Melody wanted everyone to believe after Gary was murdered that Scott was some big, scary dude that everyone should be afraid of because he's got PTSD or whatever, and he's just a big guy, so you should fear him. She even had Amanda and Chad change locks on that house. But if you go through these text messages, which is S. Farris 5, State's Exhibit, it's all their text messages post-offense when they were living on the property together. You know what she did? She relied on Scott. She had keys under the rug to get into the house, but then turned around and told people he stole stuff out of the house. If that's not two-faced, if that's not malicious, I don't know what is. That's your own son. You don't leave a key under a rug for someone you think wants to kill you or frame you. Or someone you think killed your husband. Oh, keys on the rug. Come on in. One more thing about Scott. Mr. Fogus mentioned the oath we take as prosecutors. It is our duty to uphold the law without fear, favor, or affection. There is no evidence that points to Scott in this case. You don't think if there was evidence Scott did something in this case that he wouldn't be sitting at that table with Melody? Sure make our job easier. I'm not going to indict someone where there's no evidence he committed a crime. Let's talk about a little about the Farris family history. In the beginning of this trial, y'all probably were wondering why we walk through every child's history and experience growing up in all these different houses and states, and what their dad was like when they were younger, what their mom was like when they were younger. Then you realized how far back and how deep this goes. This is not a simple family. This is not a simple case. But in order to fully understand the dynamics of this family, you had to hear all of that history. You know that this is from Emily's wedding. I want to talk about a little bit of build-up to the day of July 3rd, 2018. You've got Ted Wiley, that affair, about 8 years before Gary's death. That changed the dynamic of Gary and Melody's relationship greatly. He totally took her off the finances. He was like, you want to take out all of the money I had set aside for taxes? Great, I'm going to take you off all the accounts. You want to come back and try to work this out? Come home. Leave Ted, who, by the way, was dating Gary's sister for like 20 years before she decided to hook up with him. 2010, he dismissed the divorce that he filed. Martha Jane had her surgery in 2014. Okay? The kid said that things seemed fine between 2010 and 2014. Seemed fine. Martha Jane had her surgery, and that's when the affair begins with Rusty Barton. Emily's wedding was 2 years later. She flaunted that relationship in front of people that night. She didn't care. She had no conservative spirit about that whatsoever. And Gary had to pretend like it didn't bother him that night because his daughter was getting married. It was supposed to be the best night of her life, but you know who couldn't help but make it about her? Melody Farris. Chris testified that Gary was so upset, he said, that's the last time Melody's going to embarrass me. Then you have in 2016, Martha tells Melody about the location of her revolver. You also have in 2016, Melody telling Gary, I hope you die alone and a gruesome death. And remember, Terry Braswell, this was Terry Braswell's phone, and he had her burner phone number. This was a phone she thought nobody would ever see the inside of. She's not saying that type of stuff on her 9029 number. And then Terry says, he's gonna push you over the edge. And she says, I know, and that scares me. I told him finally to go where could not even see or hear him. It would be in his best interest. She knew she had no self-control. She hated him that much. September 2017, she gallivants out to Jamaica with Rusty. Meanwhile, she sends her debit card through the mail to Sherry Cooper to run it in Minnesota because she told everybody she was in Minnesota. She's like, I don't know why I did that. That was stupid. Don't forget, Melody betrays every person and uses every person close to her for her own benefit. She even, you saw, and I've already mentioned this, you saw Amanda's reaction to those text messages. Oof. She did not like being used like that. Gary receives an email from Christina Grant. Just FYI, your wife and Rusty Barton have been lovers for 3 years. I'll give it. Supposed to black out Miss Grant's email. Sorry. I'll give it to her. She's the only one who's bringing this to light. Everyone else sweeping it under the rug. Christina's like, nah, y'all ain't gonna get away with this. That's when Gary texts Scott about the credit card. Hang on to it as if your life depended on it. March 2018, Gary sends Melody this text message. Your profligate spending must stop. He says in the middle there, between you, Chris, and Scott, I can't keep up. You treat me like I don't exist, which is offensive, typo, my typo, given how you repeatedly betray me. Gary's in the hospital in April of 2018. Meanwhile, she's telling Rusty Barton he has like esophageal cancer and he's spitting up blood and he's on his deathbed. Even Chris said she made it sound like he was bad. And then he shows up to the hospital and Gary's like, what's that look on your face for? And he's like, I thought you were like real bad. And he was fine. He walked out of the hospital, went back to his Mountain Dew. And that's when he tells Chris, I think Melody's poisoning me. Again, that goes to his state of mind. This was all amping up. He knew something was off. June was a big month. 2018. June 6th, DirecTV comes to the house, and yes, please look at those chats, because Gary says, hey, come to the house real quick. I need to show you the issue so you know what issues when they get here. That's when DirecTV comes, that's when Scott sees that pistol. Again, this corroborates Scott. He could have said, I don't know where I saw that gun. I don't know. He knew. He knew when he saw it. He was like, actually, I was looking for a remote, which makes perfect sense. He's looking in drawers for the remote to figure out the TV, for the TV guy. That's completely reasonable and natural. He's opening drawers and he's like, oh, that's weird. A gun that looks just like the one Martha Barton described. June 25th. Rusty searches in his phone, Plain Gold Wedding Band. And you'll see text messages from Melody to him. Plain Gold Wedding Band, that was their thing. And then Gary's birthday, Jenna sees a revolver. Jenna has no dog in this fight. Her and Chris aren't even together anymore. They don't talk. She has no dog in this fight. She didn't want to be here talking about this. No motive to lie. on June 28th, Melody learns about the beach trip, which is supposed to be that Saturday. That's also not a coincidence. Then the text messages. To Emily and Amanda. These are two separate messages that she sent to two separate people expressing how angry she was that Gary got a condo for Chris and Jenna. Not a reasonable reaction. She was over it. I'm taking measures to stop this insanity. No one thought these would be the measures. But here we are. Because the next day, Gary's murdered. Again, not another coincidence. Let's talk about her motive. That first text message, I was shocked when Sherry told me you had a boyfriend, but don't blame you. From Terry Braswell to Melody. Plain gold wedding band. That's when he searches on his phone. Rusty does. This note, Crown XO, March 31st, 2014. She made a note in her phone about Rusty's favorite drink. So we know that corroborates the timeline of their relationship. And then these messages on the side here from August 4th and 5th, that's between her and Rusty. That's a month after her husband was found murdered and burned on a burn pit on her own property, who she claims that her son killed. Meanwhile, she's over here. Forever, we need us. I need you. All. You don't get more motive than that. Except she had more. All right. This is all the money she would get if Gary died accidentally. Add all those up. Okay, $4.15 million. Now, the defense wants you to believe she didn't know about it. You know what you do know? You know that she goes in his phone when he's not around. You know that she cleans that house. You know she's not stupid. She knew about his profit sharing. She called the office and asked about it. She knows where that money goes. She, again, consider the source. She is going around pretending like she's asking Emily, what am I going to do? What am I going to do if something happens to your dad? They're the ones that stood up here that said his money is her money. We all know that's true when you're married. It's either going to go to her or the kids. Probably all four. Naturally, without a will, that house was hers. You cannot tell me she thought she was gonna be broke. It's ridiculous. Afterwards, it was always about money. Melody was demanding money. She was trying to get as much money as possible. She didn't think that when he was found dead, all the finances would be frozen. She didn't think they found a bullet in his rib either. I was terrified I would be broke. Man, your husband's a millionaire. And here we have it. The condo. This is Hayes 55. Did you talk to Chris about his beach trip? What beach trip? He wants to take the girls down there the weekend after the 4th. Let him take them. I haven't gotten past him standing on my porch telling me he was going to beat me unrecognizable, and then only time he wanted to see me again was when they put me in a box on the ground. or that he continues to take money every month, of which you do nothing about. She's blaming Gary for that. There is something terribly wrong with not being able to take a beach trip with the grandkids without so much drama. I guess such a trip is not exciting enough for someone like you. Man, he knew his wife, didn't he? July 2nd. I got Gary's phone. He booked and paid for the condo for Chris and Jenna. I'm beyond furious. Amanda, oh, big surprise. Right? Always there in her mom's corner. I had to put the times on this one because this is ridiculous. Melody, did you book a condo for Chris and Jenna? Trying to, like, trap him? It's your husband. Be like, hey, I got your phone, so you booked this condo. You don't want to talk to me about that? Actually, he did talk to you about it. He invited you on a trip. You said no. I booked one for me and the girls as well. That's how manipulative and conniving she was. And you remember, in Lindsay Harris's presentation, you saw the group chat among Amanda, Gary, and Melody about she was making a photography appointment, Amanda. She invited both of her parents, and Gary said, I'm going to the beach. Melody chats her on the side. This is your time to ask him. Thanks for the invite. Manipulation, conniving, deceit. That's what she's about. Again, these text messages. The top one is a little bright. Melody to Emily. I have had it. I'm taking measures to stop this insanity. This was July 2nd. That's her message to Amanda Farris. This is the last straw with him. All right. I want to get into the timeline of events. These phone calls, these are all the phone calls that she had with Rusty on the 3rd in the evening. I didn't go before that. We know Chris and Addison stopped by the house in the evening. We know Gary went out to eat and came home. Gary went out to eat and came home around 9:30. And don't forget, John Lambert heard gunshots between 9 and 10 p.m. that night. They talked for an hour and 14 minutes at 11:45 p.m. But they talked for 5 minutes at 11:28. The call in between that is the one to Scott, 11:34, when Scott calls when he gets back home. Because, you know, she has to tell Scott to come home. She calls him and she's like, what time are you going to be home? The horses got out. And I want you to think about this. In her statements to Detective Hayes and Detective Kuykendall, she talks about these horses getting out. I think it starts like before dinner. And then it starts with like one horse, right? And then for some reason she's still chasing horses 3 hours later, but then it goes to two horses. And then she's like, oh, but then the third one got out after that. Inconsistent. You weren't chasing horses. You were murdering your husband. She had to call Scott because she didn't know what time he'd be home. She had to call Scott to see what time he'd be home. Because then, when she says, well, the horses got out, and he's like, okay, I'm coming home. She's like, well, I got them put up. Okay, then why are you calling? It doesn't make sense. The horses are a cover-up. When she calls Scott, Scott's all the way up there at the lake. She calls him at 10:52. What time are you gonna be home? All those calls with Rusty in between. I want to talk about this notification. At 12:24 a.m., the morning of the 4th, so the night of the 3rd, the night Gary is killed, she uses her debit card to purchase minutes on Straight Talk. Y'all heard a lot of testimony. 1, about how she doesn't have a credit card. 2, about how Gary would get financial alerts for all of her purchases. Lindsay testified, Ms. Harris, testified. This was the only alert that popped up in his email, in his phone, for Straight Talk. That's not a coincidence. She knew Gary was dead. So using her debit card to blast that she has a Straight Talk phone, not a problem.
She said, Gary is in the burn pile. No, she said, he is in the burn pile. And I said, what? And she said, he's in the burn pile. And I said, do not say another word and do not tell me anything. I do not need to know.
That's what that 220 call was about. Now, again, believe what you want about Rusty. We all know he knew more than he came in here and told you. We all know that. We're not stupid. They talked for an hour and 35 minutes at 11 whatever, and then another 35 minutes at 2:20 a.m. But that's all he was willing to give. But that's enough. And you know that that's how it happened because he gave you the context and he told you when that call happened. Mr. Ray talked about Detective Botsong using this open source document or program for the CPAP machine. All right, the date is the 3rd. It ends at 7:48 a.m. That's the last data for that CPAP machine for Gary Farris going to sleep. Now, you got the raw records too. Look at that. Oh, 7:48 a.m. It's the same. The data, the raw data, shows he never, ever went to sleep the night of the 3rd. Now, I want to talk about this map. All right. Got a little bent. All right, see where that dot is? And that's Gary's phone. The morning of the 4th at 6:37 a.m. till 7:21 a.m. Right there at that burn pile. We know Gary's dead. And we know it goes from the house to the burn pile. You'll have that with you in the jury room. And then it goes back to the house. 7:58, 8:21, 9:05. It's back at the house. She's on the phone with Rusty all morning. And you know Scott's location during this time. It's in here. He left for the lake. He was 20 minutes away. The only one home was Melody. That phone was either on Melody or on Gary's dead body. But you know who wasn't there? Scott. And Melody was by herself. You know Rusty wasn't there because she's on the phone with him the whole time. Well, and you heard testimony that he was actually in Tennessee. But also, we know what time she left for the lake. She left 12:47 p.m. She puts that location Amanda sends her in her maps and heads out to the lake. Now the thing about Dr. Pope's testimony in that 24-hour window is she said that that was dependent upon the fuel. And you heard testimony that that burn pile was huge. You know what she did? She lit that burn pile and she left. The 3 calls with Rusty Barton the evening of the 3rd and the morning of the 4th total more than the other 15 calls that they've ever had between those hours. Again, that's not a coincidence. She was freaking out because she just killed her husband and had to figure out what to do with him. You know who she turned to? Rusty. What do I do? Yeah, I'm going to talk about our activity. The 3rd. The 7th, September 7th, 2017. September 30th, 2017. And the 3rd, July 3rd, 2018. Those are the 3 days she had the most activity between. This is a 1 hour period. 1 hour. From 11 p.m. to midnight, okay? Now, we talked about Jamaica, the one on the 7th. That was probably a data dump, okay? All right, fine. Let's get rid of it. 2. The 2 most active nights she has ever had in a year are gallivanting about Broadway when she's out in Nashville with Chad and Amanda, and the night she murdered her husband. That tracks. That makes sense. That's reasonable. This is also not a coincidence. Money. We know Melody didn't have a credit card. The only card she had was a debit card. And that card is the one that ended in 0078. The one Scott used at that ATM that morning that he got from the house and brought back. Okay, there's that ATM withdrawal. That's the one he brought back to his mom. Even Melody says about Scott, and he has a credit card. I don't even have that. We know that. That 0078 card is her only card. Until law enforcement empties her wallet. That card on the right, ending in 1727. That's the card Gary got mailed to his office less than a month before his murder. That was a new credit card. That's his office address and that Bank of America activity alert. And that's her transaction at Walmart the morning of July 5th, before Gary's remains were discovered. Oh yeah, by the way, the trip to Walmart that she doesn't mention to police ever, that she says she's literally interviewed on the 5th and on the 6th. Leaves it out, says she's just, I don't know, cleaning up after the girls, lays in bed. Why don't you talk about this trip to Walmart? Look, she even activated a phone card. What was so important you had to run out to Walmart that morning? Could it be to restock on cleaning supplies? Is that why you didn't want law enforcement to know you went to Walmart? Or because you spent $450 on a credit card that you didn't have until you took it out of your dead husband's wallet? Both. She needed to wash those towels. She needed to Clorox that floor. She bought a lot of soap, a lot of bleach. And we know it was her because she bought wine and showed her ID. Let's talk about the truth of July 5th, 2018. Melody is actually the one who pointed out Gary's remains to Scott. And yet she's letting everybody gallivant around saying, Scott found him, Scott found him. That's not true. And she knows it. She's the one who told police also that corroborated Scott. I said, hey, did you put a goat in the fire? That was her pointing out the remains to Scott. Because if you don't have a body, you don't get the money. She knew he had to be found. Melody actually knew the night before that the girls couldn't find him. Addison said that. She wasn't concerned. And yet she pretends like the morning of the fish, she didn't know he was missing. Melody only started looking when Amanda got there. She was sitting on the stoop, just like, hey, yeah, we can't find Gary. Okay, well, how long have you known about this? Actually, since last night. Well, that would be the wrong answer. That would make her suspicious. And when Amanda described the events on the 5th, boy, were those vastly different from everybody else's. Thing about it, and what got me was she was like, nobody asked me. Weren't you told not to talk to these? You were the one who didn't want to tell what happened. So then you live with your mom for 2 years and decide to tell what happened, and by then, you've been completely tainted. Scott testified he went to go look for the CPAP and the gun that he used for duck hunting to see if maybe he's out duck hunting. All those comments about a missing gun, that's not true. He didn't mention that until after he went in the basement, thought to look for that 38, saw it was gone. Then he came up and was like, oh, yeah, by the way, this 38 is missing. He didn't mention a missing gun before that. Think about the source of all that information. That's Melody being vindictive and planting thoughts in her daughter's head. on the 5th, and you go back and you hear Melody's statements. Scott's health issues, suicide, Chris steals money. Here's the thing. Here's how it went down, okay? I have a picture of an octopus up there. Do you know what an octopus does when it feels threatened? It squirts ink in the water to escape. The closer she felt like she was getting into trouble, the more she felt threatened, she started spewing all this ink about her kids. She even talks about Chris Payne. He wasn't even in the state. I mean, she does not care who she throws under the bus to save herself. It is actually insane. And it's such a reach. Scott likes to shoot guns. Okay. Chris takes money. Okay, well, he was in Buckhead, so this is going nowhere. And then the suicide, it's funny because she says, no, he wasn't suicidal, and then when she feels threatened, she's like, oh, well, yeah, no, he used to be suicidal before we got married. Once she realized that the jig was up, ooh, she was frantic. The only person she didn't throw under the bus was Amanda. Because she'll need one child to support her. She just needs one. It's all about what she wants, what she needs. It's not about anyone else. She prided herself on her house and her things. She liked her things. She wanted to keep her house immaculate. She talked about that. She decorated it to a T. Not my style, but, you know, to each their own. And yet, it was pretty dirty on the 5th. Let's talk about the blood. Don't forget that Deputy Riley walked in that house and there was a candle burning by the basement door. It's not a place for a candle to burn. And it smelled like bleach. We've got Gary's blood right there on that basement floor. The defense wants you to believe these are all different sources of different things. That's not reasonable. We've got a blood trail. And it goes from the top of those basement stairs, where that attempted cleanup is, down the stairs, into the basement. See that big bottom splotch? That's those stains right there on the left. That's blood. Those evidence markers that were Gary's blood, right along this trail. That's in the basement, in front of the bar. It is not reasonable to think that there is a legal justification for all of that. That's not reasonable. What's reasonable is that's a crime scene. Because we have a man who was shot twice at least, burning in the burn pile behind this house. To think otherwise is to seek doubt. And that is not your duty. Needs an opportunity. They had a lot of stuff. They had a lot of farm equipment. You know who's farm girl? Melody Farris. And she's, you know what? She gets it done. She's determined. She she's self-sufficient. And you know what really motivates someone? Getting caught for murder. It wouldn't have been easy for anyone to move that body. Not Scott by himself, not Chris by himself. Anyone would have needed something. And you know what? It's okay if you all think different ways in which she moved his body. One of you could think she used the tractor. One of you could think she used the RTV. One of you could think she literally just got down and rolled him there. It was all downhill, you saw. One of you could think she tied him up like a deer to the back of the RTV and dragged him over there. But he ended up on that burn pile. And a fairy didn't put him there. A murder fairy didn't put him there. No one else. There is no evidence anyone else is on that property. And to think differently is to seek doubt. She was in good shape, people. She had no choice but to move him, or she would have been caught literally red-handed. She's not stupid. That's why we're here today. Now we're going to talk about guns. Scott doesn't have a pistol. We introduced that. She is a self-proclaimed not a bad shot. She told that to Terry. That means she's shot guns before. And remember, she's a farm girl. And a .38 revolver, pretty easy to shoot. Martha Jane. Ooh, they're mad about Martha Jane. She is, as Mr. Fogus said, God-fearing. She needed to be right with God. She's not going to lie to you. She noticed that gun was missing after Gary's murder. And it's reasonable for her to think that we can put a gun in her hand for this murder. It's reasonable for her to think that. But it wasn't until she realized we didn't have a murder weapon, and she was like, oh, they need my help. I gotta say something. And it was in a leather holster. You know who that gives credibility to? Scott. We know he was shot at least 2 times. These were shot from the same gun. And no, they're not consistent with the 38 bullets found in Scott's apartment. They're just not. And they're not consistent with a .357 or whatever other gun they think may be involved. No. It's consistent with 38 special revolvers. Not .357. I'm going to talk about Melody's lies. She was interviewed by Sergeant Hayes and Sergeant Kuykendall. And when she was told that her husband of almost 39 years was shot, do you remember what her question was? Do you know what kind of bullet? That would not have even crossed my mind to ask. No suspicion. What do you mean he was shot? What? I thought he just, what do you mean? He had health issues. She's not worthy of belief. She lied to them about Ted Wiley. She lied to them about her phone. She lied to them about Rusty Barton. Her XO tattoo. Going to Jamaica with Rusty. Gary going out to eat on the 3rd. She never mentioned that. Because you know what? She was waiting inside that house with her gun, ready to confront him. She lied about going to Walmart. She lied about how much money I spent nothing. Man, profligate spending? I had to look that word up. She kept saying Chris booked a beach trip. No. She knew Gary booked that. But she wanted to blame Chris. Gary being on his deathbed, coughing up blood. Occam's razor, y'all. The simplest answer is the truth. The simplest answer in this case is where all this evidence points, and that is to Melody Walker Farris. It points to no one else. This is not a series of coincidences. She was not framed. She's not the unluckiest woman in the world. And again, there is not a series of justifiable reasons that explain her conduct. There's just not. And there aren't justifiable explanations to explain the evidence. July 24th, Rusty says to law enforcement, she told me he's in the burn pile. She's arrested a year later, booked into Cherokee County. They have a jail call on June 24th, and whoop, on June 25th, he recants that statement. Y'all, there's Melody Farris for you. That manipulation. She knew Rusty was her Achilles heel in this case. She knew that. She had to shut it down. You know what she was really hoping? This is how she wanted it to go down. She knew the only way out of this marriage was murder. She knew that. I don't know why she thought that, but that is what she knew. Murdering the father of her children. She was hoping his body, being on that burn pile, would be chalked up to a health episode. She didn't think the sheriff's office would find that bullet in his rib. She just didn't. That's clear. She didn't think there would be blood left in her home. She didn't think anyone would be looking for it. She didn't think law enforcement would be all over that house. Well, we found it. And we kept digging, and we found more and more and more. We found out about your affairs, your disdain for your husband, your obsession with money and things and materialism. She never once encouraged law enforcement to find the person that actually did this. She didn't think this is how any of this would play out. She manipulated her own mother to have an affair with Ted Wiley. She manipulated Martha to have an affair with Rusty. She manipulated Amanda to go with her to continue her affairs with Rusty. She manipulated Emily. She would go to Nashville to see Emily and disappear to go see Rusty. She used all of the people in her life. She used Sherry Cooper to see Rusty. She used Rusty to try to get away with murder. She used Scott Farris to try to get away with murder. She used Chris Farris to try to get away with murder. And she used Gary throughout the entire marriage. She had the motive, she had the means, and she's the only one who had those, and she's the only one who had the opportunity. There is no evidence this was Scott. Mr. Fogus told you in opening we had to shrink the world. That's what he meant, and that's what we did. There is no evidence that she had help. That would make our job a lot easier. Her help was on the phone. It was Rusty Barton. There is no evidence it was anyone else. This evidence demands a verdict of guilty. Do not reward this criminal behavior. Do not reward her for almost succeeding in burning up her husband's body, unrecognizable to the point where doctors, forensic anthropologists cannot determine if any organs in his body had trauma. And no, you cannot tell me that there were no injuries on bones. Half those bones were gone. What you know is there was a bullet in his body and a bullet found in the basement with his DNA on it. And a gun that went missing from Martha Barton, who she had access to. She knew where that gun was. Do not reward her for almost concealing successfully the death, the gruesome death of her husband. Hold her accountable. Melody was the only one who wanted him dead. She was the only one who would benefit from him being gone. She was the only one repeatedly betraying him. There are no games here. Murder is not a chess game. It is malicious. And Gary did not deserve this. The last thing he saw was staring down the barrel of a .38 revolver in the hands of his bitter wife, who was constantly betraying him. But this was the ultimate betrayal. Hold her accountable. You are the voice of Cherokee County in this case. You have the evidence to convict her beyond a reasonable doubt. We have proven it to you, and you have it. It's in the form of thousands of exhibits, testimony from the stand, audio, a lot of audio. If there is something you want to see or hear that you can't find back there, you send a note out to the judge. Do not reward her for being a smart criminal. You are the voice of Cherokee County that we do not tolerate this. in this county. You do not get to shoot and mutilate your life partner. You don't get to take away the grandfather of your grandchildren. That is not your choice to make. The ultimate betrayal. Gary will not walk through that door. And that's because she took him off this planet. Find her guilty of all the counts in this indictment. The evidence and the law demand it.
All right, I want everyone in the audience to stay where you are. Jurors, y'all can take a 15-minute break, and then I'll give you the charge. That's going to be probably 40 to 50 minutes. Everybody, y'all can stand up if you want to, but y'all stay where you are. All right, I'm going to address the audience for a minute, and folks in the back, y'all can keep rolling while I do this. The first thing I'm going to do is I feel compelled to talk to the folks out in TV land for a minute and defend the state of Georgia and clarify something Mr. Weaver brought up in his closing arguments, and that is Georgia has had a constitution since we were enabled as a state. In fact, we've had somewhere between 10 and 12. No one's exactly certain how many, and I'm not a constitutional scholar. But the most recent version of our Constitution was adopted in 1983. That wasn't the first version of our Constitution. Yes. All right. Yeah, well, the folks out in, the folks that are watching us in New Zealand don't. All right. All right. Couple of ground rules for those of you in the audience. We're going to start charge. All right. This is something that's not covered in TVs and movies very often. It is long and it is relatively boring. But there are two times that I close my courtroom and don't let people come in and out. One is during adoptions, which are closed proceedings. Two is when I am charging a jury. It is critically important that the jury hear the instructions that I'm giving them. The bailiff will be manning the door and will not let anyone in or out. We're going to take a 15-minute break, and if y'all want to take a break, please do. If you want to remain with us after the break is over, I'm going to give 5-minute warning and I'm going to start. But once I start, you will not be allowed back in the courtroom. So if you don't want to remain for the entire 45-minute closing charge, then don't come in. Most of the lawyers in the building that would usually come in and watch a closing, because they typically do, are watching them on the internet so they can tune out to this part because it's, like I said, relatively boring. All right, that's really all I need to tell y'all. I need the bailiffs to move the easels. I've asked the clerk to give me a copy of the indictment. Tracy needs to find my copy of the stipulation because it disappeared that was up here. And yeah, I was going to read them off mine and not the one for the jury. All right, with that, we'll be in recess for 12 minutes or so. I haven't checked it back, but I'll fold it down, put it on the floor, move it out of the way. Move the lectern, please. Yes. I'm gonna move the remote control off my stack of books here.
Oh no, I still never did. You never did it?
All right, there's a copy of the indictment to go on the, Julian, stick that on the table. The copy of the, Mr. Weaver, the copy of the indictment I have down there isn't signed, but that's typically what I want them out of the way completely. We've got a juror in that back corner, so I want them taken down, moved out of the way, tossed, whatever.
Are you still thinking about going to 6:37 o'clock tonight?
I'll let them go as long as they want. I doubt they'll want to stay late, but I'll just try to get a feel from them. I'll check. I'm not going to run them off.
it wouldn't spread quickly like that because it's an actual walls and actual murder.
to not stay. All right, ladies and gentlemen, you are considering the case of the state of Georgia versus Melody Walker Farris. Due to the length of this charge, I am attempting to have it in writing and have you read along with it. I've been doing this for some time now. I have concerns about presenting the jury charge to you in writing in your hand. I find it is easier for you to read along with me as I give it to you. There is a movement among judges to provide juries with a written copy of the full charge. There are too many issues involved that I am not comfortable doing that. I do not know which one of you is a high school English teacher and will dissect the charge or my jury instructions. I call it a charge. It's the jury instructions, but we charge the jury is what we call it. I don't know which one of you will dissect the charge and come up with a completely different meaning of it than I intended based upon a misplaced comma. This document is not grammatically perfect. It has errors and uses the wrong pronouns or tense or refers to multiple defendants instead of a single defendant or vice versa. I also like to randomly capitalize words, so to the extent that there are any of those errors, please consider them as the proper pronoun, tense, or plurality. It also has headings and numbering that you are not to consider. But if I don't put that in the charge, I can't keep track of what is contained in it. There may be different type styles, fonts, or sizes as I cobble the charge together from various sources, including lawyers. You are not to consider anything being more or less important based upon text size or style or font. This charge is to be taken as a whole. It would take another full day or longer for me to attempt to get the charge as close to perfect as possible, to give it to you in writing, and then it will still likely contain a mistake. I may even edit this charge as I give it to you. The grand jury has indicted the defendant with the charges of malice murder, felony murder, aggravated assault, concealing the death of another, and making a false statement. You will have a copy of the indictment out there with you. I'm not going to read it to you. The lawyers have referred you to it. I've read it to you before. As I will go through the counts. Count 1 is malice murder. Count 2, felony murder. Count 3 is aggravated assault. Count 4, concealing the death of another. And count 5, making a false statement. I think, Shane, if there's a copy of the, I don't have the verdict form up here. I think we put it on the table.
We got it.
Yeah, if you got, yeah. Just let me. That's just, I have a stipulation, yeah. Thank you. Anyway, you'll have a copy of the indictment out there with you. The defendant has entered a plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. The copy of the indictment that you have out there does not have Ms. Farris's signature on the not guilty line. That is the original that's in the clerk's file. This copy was made from the original indictment when it was filed. Neither the indictment nor the plea of not guilty should be considered as evidence. Likewise, you should not consider the length of the indictment or the number of charges against the defendant as evidence of guilt. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of this case with the presumption of innocence in her favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offenses charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crimes charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. The objective of this trial is to discover the truth. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all of the evidence presented. Then you must apply the law that I am giving you in this charge to the facts as you find them to be. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendant. Your oath requires that you will decide this case based on the evidence. Evidence is the means by which any fact that is put in issue is either established or disproved. Evidence includes all the testimony of the witnesses and any exhibits admitted during the trial and any stipulations. Evidence does not include the indictment, the plea of not guilty, the opening or closing remarks of the attorneys, or any of the questions asked by the attorneys. Evidence may be direct, circumstantial, or both. Direct evidence is that which may be seen or heard, or otherwise directly sensed, such as by smell or taste or touch. It may be brought into court in the form of exhibits or the testimony of direct witnesses to such matters. It is evidence that points immediately to the issue in question. When direct evidence, by inference, points to an obvious, likely, or reasonable conclusion, even though that conclusion was not directly seen, heard, smelled, tasted, or touched, that is said to be circumstantial evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in light of your experience. It is evidence that only tends to establish a conclusion in question by its consistency with such conclusion or elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. The law does not require a higher or greater degree of certainty on the part of the jury to return a verdict based upon circumstantial evidence than upon direct evidence. You would be authorized to convict only if the evidence, whether by direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond a reasonable doubt. The parties have entered into stipulations that have been approved by the court, and I read that to you earlier, but I'm going to read it to you again now. In this case, the parties have entered into stipulations that have been approved by the court. The named victim in this case, the decedent whose remains were found on the property of 2155 Purcell Lane, Alpharetta, Cherokee County, Georgia, 30004, on July 5th, 2018, is Gary Wayne Farris, with his date of birth. All of the phone records collected throughout the investigation related to Gary Wayne Farris's death are authentic and shall be admissible at trial. All the Google records obtained through the investigation related to Gary Wayne Farris's death are authentic and shall be admissible at trial. All the records obtained for cell phone towers, AT&T and Verizon, during the investigation into Gary Wayne Farris's death are authentic and shall be admissible at trial. 5, all the digital evidence, including cell phone data obtained, extracted, searched, or analyzed during the investigation into Gary Wayne Farris's death is authentic. All the reports and any opinions thereof from the GBI, Division of Forensic Sciences, are authentic and shall be admissible at trial. And you'll have a copy of those stipulations as part of the evidence as well. Where parties stipulate facts, that is the nature of evidence. You must take that fact or those facts as a given without the necessity of further proof. You make all decisions based on the evidence in this case. Where parties stipulate to testimony, documents, or exhibits only, this is in the nature of evidence. You may take that testimony as if it were given in court, and you may rely on it if you find it credible. However, either party may dispute such testimony by other evidence. You make all decisions based on the evidence in this case. The jury must determine the credibility of the witnesses. In deciding this, you may consider all of the facts and circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the case, and their personal credibility as you observe it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their special training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinion based upon that training and experience. You are not required to accept the testimony of any witness, expert or otherwise. To impeach a witness is to show that that witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. The credibility of a witness may be attacked by disproving the facts to which the witness testified. The credibility of a witness may also be attacked by showing bias toward one party or another. This may be shown with evidence of specific instances of conduct of that witness in question that may relate to that witness's bias. In determining the credibility of any witnesses whose credibility have been attacked, as I have just described, in any testimony by that witness or witnesses in court, you may consider evidence offered to support the credibility or believability of such witness that shows a lack of bias toward a party. The credibility of witness may be supported by other evidence, and you may consider such evidence in determining the credibility of a witness. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before this trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. The testimony of a single witness, if believed, is sufficient to establish a fact. There is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. Evidence relating to DNA comparison has been admitted for your consideration. Identification by DNA comparison is considered opinion evidence and is governed by the law concerning opinion testimony as it has been given to you. As opinion testimony, evidence relating to DNA comparison is dependent upon many factors. Among the factors are the credibility, believability, and accuracy of the witnesses who were involved with the process of obtaining, identifying, preserving, recording, and maintaining the physical evidence, and upon the accuracy and validity of the testing procedures themselves that were used to form such opinions. All of these issues are matters for you, the jury, to consider and determine. It is for you to determine what weight, if any, you will give to the evidence relating to DNA comparison in your decision in this case. Sometimes evidence is admitted for a limited purpose. Such evidence may be considered by the jury for the sole issue or purpose for which that evidence is limited and not for any other purpose. Evidence of prior difficulties or lack thereof between the defendant and the alleged victim, or between the defendant and a witness or witnesses, has been admitted for the sole purpose of illustrating, if it does, the state of feeling between the defendant and the alleged victim or witnesses, or the reasonableness of any alleged fears by the defendant or any alleged victim or witness. Whether this evidence illustrates such matters is a matter solely for you, the jury, to determine, but you are not to consider such evidence for any other purpose. The defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. However, the defendant does not have to present any evidence nor testify. If the defendant chooses not to testify, you may not consider that in any way in making your decision. A statement the defendant allegedly made has been offered for your consideration. Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary. In order for a statement to be voluntary, the statement must be freely and willingly given and without coercion, duress, threats, use of violence, fear of injury, or any suggestion or promises of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of a free will and not under compulsion or any necessity imposed by others. The burden of proof is upon the state to establish that the statement was voluntary, that is, freely and willingly made. If you do not find the statement was voluntary, you may not consider it for any other purpose. You should consider with great care and caution the evidence of any out-of-court statement allegedly made by the defendant offered by the state. The jury may believe any such statement in whole or in part, believing that which you find to be true and rejecting that which you find to be untrue. You alone have the duty to apply the general rules for testing the believability of witnesses and to decide what weight should be given to all or any part of such evidence. A defendant's out-of-court statement that is not supported by any other evidence is not sufficient to justify a conviction, even if you believe the unsupported statement. This defendant is charged with a crime against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of an act and intention. Intent is an essential element of any crime and must be proven by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you believe that it existed from the proven facts before you. Intent may be inferred from proven circumstances or by acts and conduct, or it may be, in your discretion, inferred when it is a natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a penal statute, but means simply the intention to commit the act that is prohibited by a statute. The defendant will not be presumed to have acted with criminal intent, but you may find such intention, or the absence of it, upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to, that the acts of a person of sound mind and discretion are the product of that person's will. A person of sound mind and discretion intends the natural and probable consequences of those acts. Whether or not you make any such inference or inferences is a matter solely within the discretion of the jury. Knowledge on the part of the defendant that the crime of making a false statement was being committed and the defendant knowingly and intentionally participated in commission of such crime must be proven by the state beyond a reasonable doubt. If you find from the evidence in this case that the defendant had no knowledge that that crime was being committed, or that the defendant did not knowingly and intentionally commit the offense of making a false statement, then it would be your duty to acquit the defendant. On the other hand, should you find beyond a reasonable doubt that the defendant had knowledge that the crime of making a false statement was being committed and that the defendant knowingly and intentionally participated in the commission of it, then you would be authorized to convict the defendant of that charge. The mere presence of the defendant at the scene of a crime without more does not authorize a conviction. The evidence must show that the defendant committed the crime or participated in its commission. For malice murder, the state must prove that the defendant caused the death of another person unlawfully and with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred, rather is the unlawful intent to kill. You may find malice when the circumstances show that the defendant acted with a deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be a significant provocation, and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder, regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or killing and moved the defendant to do it, that is enough for the killing to be murder. Premeditation typically means a prior decision or plan to do something. Premeditation is not an element of murder and does not need to be proved by the state for you to find malice aforethought. However, in determining whether malice existed at the time of the killing, you may consider any evidence of premeditation or lack of it. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. For felony murder, the state must prove that the defendant caused the death of another person by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Aggravated assault is a felony. You may find the defendant guilty of felony murder if you believe that she caused the death of another person by committing the felony of aggravated assault, regardless of whether she intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. When a defendant unlawfully injures another person, you may find that the injury caused the other person's death only if the state proved that the injury was itself the cause of death, or directly and significantly contributed to the cause of death, or significantly sped up the death, even though the death would have eventually occurred anyway. A person commits an assault when that person attempts to commit a violent injury to the person of another. For aggravated assault, the state must prove that the defendant assaulted another person with a deadly weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person. A firearm, when used in the way a firearm is ordinarily used, is a deadly weapon. For concealing the death of another, the state must prove that the defendant concealed the death of another person, which hindered the discovery of whether that person was unlawfully killed. A person commits the offense of false statements when that person knowingly and willfully falsifies, conceals, or covers up by any trick, scheme, or device a material fact, makes a false, fictitious, or fraudulent statement or representation, or makes or uses any false writing or document, knowing the same to contain any false, fictitious, or fraudulent statement or entry in any manner within the jurisdiction of any department or agency of state government or of the government of any county, city, or other political subdivision of this state. The law provides that criminal actions shall be tried in the county in which the crime was committed. Venue, that is, the crime was committed in Cherokee County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in this indictment, just as any other element of the offenses. Venue must be proved by direct or circumstantial evidence, or both. All right, you'll be provided a verdict form for each offense the defendant is charged with committing. Each count is to be considered separately. For each count and each For each count on the verdict form, if after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt the defendant in Cherokee County, Georgia, did commit the offenses on the date of the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. For each count on the verdict form, if you do not believe that the defendant is guilty, or if you have any reasonable doubt as to the defendant's guilt, then it will be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. As I mentioned, you'll be given a verdict form. This is the verdict form. It has each of the counts charged in the indictment on the verdict form, and there is a box, guilty or not guilty. Circle or check one only for each charge. And then at the bottom is a place for the four-person signature. If you'll also put your name below the signature line and date it. I think there's some pens back there. Make sure you have a pen if you're the foreman and you're filling out the verdict form. I had a few juries do it with the pencils that we provided you, and I decided that was probably not a good idea. By no ruling or comment or action that the court has made during the progress of this trial, nor any ruling in any pretrial hearing, has the court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the defendant. Your verdict should be a true verdict based upon your opinion of the evidence, according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively, without favor, affection, or sympathy to either party. You are only concerned with the guilt or innocence of the defendant. You are not to concern yourselves with punishment. One of your first duties in the jury room will be to select one of your number to act as foreperson. That person will preside over your deliberations and will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if you are convinced that it is wrong, congenial, or to reach a verdict solely because of the opinions of the other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You are also not permitted to conduct any research about this case, including persons or places or legal concepts mentioned during the trial. These rules apply not only to in-person communication, but also to communications or research using cell phones, text messaging, websites, blogs, or social media of any kind. As I instructed y'all before, y'all will take your device, the bailiffs will take up your devices and put them in a box, and they will be in the hallway during the course of your deliberations. We will take a short break while we gather everything up to present to you to take out to the jury room. During that period of time, y'all have an opportunity to call home. Again, you can tell them that y'all are starting your deliberations, that they will hear from you at the end of the day when y'all break or when y'all reach a verdict. I will give you additional instructions when we break for the day if y'all decide to come back and deliberate tomorrow. I've had jurors in the same situation as you who have decided after 6 hours of closing argument and instructions from the court that y'all are done and want to come back and start fresh in the morning. If that is what y'all want to do, that is perfectly fine. If y'all want to stay here till 8 o'clock or 10 o'clock or 2:30, as I told y'all I had a jury do, y'all are welcome to do that. If y'all stay late, we'll order some food for you if y'all choose to do that. I've also had folks that have been deliberating for some period of time who decide that they want to get away from each other, go off-site, have dinner on their own, and then come back and kind of refresh. Again, I will leave that up to y'all's decision, and how you want to deliberate, I will, for the most part, leave up to you. There is a lot of evidence in this case. The attorneys and I have gone through it, made sure that y'all have everything you're supposed to have. Do we have a list of the exhibits for them? All right. All right. All right. There's a list to help guide you through all the evidence as best we can. For, I think, all of the photographs, there are hard copy printouts of the photographs, so you don't have to ask to see those again. If you want to see videos or hear recordings, despite my technological prowess, I have been trying to come up with a way for y'all to view digital evidence in the back. Nobody else other than me trusts that process, and so therefore we haven't done it yet. That is still something I intend to do before I retire. But for now, if y'all need to review any digital evidence, you will have to request it in writing, and you will come back in here, and we will put it on the screen or put it on the audio. Along with that, if you have any questions, you can, again, through your foreman, you will give me those questions in writing to the bailiff. I will do my best to answer those questions as best as I can. You may not like my answers. For any communication between you and the court, it has to be in writing through the bailiff. Now, I will probably, if y'all are here this evening around 6:30, I will ask the bailiff to check in on y'all and see if y'all want to stick around for a little bit longer and whether you want us to order you dinner. That will be the extent of the conversations that I have with you through the bailiff, will be really timing. Any communication to me needs to be in writing from you. If you have requests, put them in writing, make a list. Let me explain to you what that process will look like. It will take, the district attorneys are going to go upstairs to their office. The defense attorneys have a conference room out front. They're going to be there. The DAs are going to be up there. I'm going to be in the back, and the folks in the courtroom are going to kind of scatter. When y'all send me a question, I have to notify the attorneys. I've also told the media I will inform them so that they can cover that part of the proceeding. It's going to take 15 or 20 minutes for me to gather everybody up. Maybe a little shorter than that, but it will take 15 or 20 minutes before I can respond to you, because I will have to discuss with the lawyers what we're going to tell you or show you or get it pulled up on the screen. Therefore, I suggest that if you have any requests or any questions, that you give me more than one if you have more than one thing you want to look at or think about or ask questions about. Again, you may not like my responses. I will tell you this because this is generally a question that I get. We want to see X, Y, or Z evidence that was not admitted during the trial. The evidence is closed. There will be no other evidence that you will receive other than what you've been given. The only thing that you have that you don't know, that the recorded while we did the run-through of the jury view. If you want to see that video, that is an exhibit that y'all have not been presented. But we have agreed that y'all can view that, and that is part of the evidence. And if you would like to rewatch the lawyers and I walking through the jury view, y'all are welcome to request that. It will take a few minutes for us to discuss what we're going to present to y'all. Then y'all will come back out and we'll go over that. I will generally give you an opportunity to, especially if you're wanting to see other evidence, to huddle up and talk to each other real quick and see if there's something else you want to see. The recordings are lengthy. If there's a specific portion of a specific recording that you want to hear, and you know one of you took notes and know about whichever part y'all want to listen to, give us that information as best you can, and we will attempt to find it. We will try to figure out what you're asking for. We will play it for you, and then we will ask you if that is in fact what you wanted us to play for you. If it's not, then we will try to find it. Y'all understand that process? All right. Whatever your verdict is, it must be unanimous. That is agreed to by all. The verdict must be in writing and signed by one of your members as foreperson, dated, and returned to be published in open court. Georgia law does not provide for the alternate jurors to sit in on the deliberations of the jury. In a few minutes, we will bring the alternates back. We will identify which one of you are the alternates, bring y'all back in here, and I will give you additional instructions. Based upon the length of this case and how long I anticipate y'all may take in your deliberations, the alternate jurors will not be, y'all will still be on call and still be on the jury and will not be able to work, etc. I will give y'all more instructions about that. If an alternate juror is needed, deliberations actually begin anew. And y'all essentially start back over with an alternate. As I've indicated to y'all, once the case is yours, you'll be in control of when you will deliberate and when you won't. Once you go back to the jury room, I'll ask you to turn off your devices, not to turn them back on until your verdict is presented. If I intend to take a recess for lunch, if we take a break, I will let y'all know that we're taking a break. I know the lawyers are probably tired of the offices, and so we are not going to take a longer lunch break. We're going to be on call while y'all are working this afternoon if y'all choose to do that. If y'all need to take a short walk down the hall, that's fine. You don't have to let me know that. If y'all want to take a break and go off site, then y'all need to ask for us to be able to do that. If a group of y'all want to go downstairs in the short period of time after I send y'all out, that would be a good time if someone wants to go downstairs and get a Coke. If someone needs to go take a smoke break, I will give y'all 15 minutes or so to take a short break before y'all begin your deliberations. During that time, we will try to get the alternate jurors back in here quickly, so no one go anywhere until I tell y'all to. We'll bring the alternates back in. I'll give them some instructions on what they will do for the rest of the day and the rest of your deliberations. In order for y'all to deliberate, the following things must occur. There must only be 12 of you. You all must be in the jury room. You must have all of the evidence, which includes the indictment, the stipulations, and the verdict form. Unless all of those things are present, you may not discuss the case whatsoever. So if one of you goes to the bathroom, y'all stop talking. If one of you goes down and has a smoke break, y'all don't talk about the case. Until all the evidence is gathered and presented to you outside, y'all don't discuss the case. Do not touch these once you turn them off. During the break, you can call home. I've given you that instruction, but I'm telling you again. If there is something you need, ask for it in writing from the bailiff. I have a calculator up here. We have a large writing pad, if you want that. If you want the easel, the writing pad, some markers, I'm going to send those out for you anyway. But if there's anything else like that you want, ask for it. Don't try to obtain it on your own. All right? With that, y'all step out in the hallway for a moment. You can make your phone calls. We'll identify the alternates and bring them back in here.
This is on my desk.
You had it.
I did have it.
I told you it was up here.
Would you like to keep it
I knew I'd lost it somewhere.
for the court TV room? Or do you want us to keep it
You
over
just
here?
hold on and we'll 91.